compliance has always been a hot issue, I think, both in the UK and certainly in the US, and it continues to be really important even during this pandemic. I think it is something that can often get forgotten about, especially when individuals are working remotely and maybe not in their normal routine, but certainly it is an aspect that everyone should continue to make sure is front and center. Marc, I know the USCIS came out with some great changes in terms of the compliance for the I-9. Can you go into some of those changes?
Sure. Yeah, so, here in the US, as is the case in the UK, large portions of our workforce were working remotely once the pandemic started. And in some states it was mandatory, some states it was optional. But with that, it made it very difficult for employers to comply with the I-9 requirement. And in the United States, the I-9 is a form that every employer has to fill out for every new employee, whether they're not a U.S. citizen or even if they are a U.S. citizen, to prove that they have authorization to work in the United States. And obviously, and the I-9 rules typically also require that when you're completing that form, the employee has to provide certain documentation that proves their eligibility to work, and the employer has to physically inspect those documents in person. You're not allowed to look at a copy of the document. You're not allowed to have them fax it to you or email a scanned copy to you. You have to physically inspect the document. And so obviously with workers working remotely, HR professionals, hiring professionals working remotely, that was very difficult for them to be able to do that. So one of the nice changes that the government made to bring some leniency to that process is that there's a longer time frame where you can go ahead and collect those documents from the employee, but also you do not have to physically inspect those documents. So during the pandemic, employers are able to look at copies of the documents, and that will be considered to satisfy the rules. Now, once the national emergency is over, employers will be required to re-inspect those documents physically at a later date, but for now they don't have to do that, which is a huge help to most employers.
Yeah, absolutely. And Rahul, in the UK, your counterpart of the I-9 would be the right to work check, correct?
That's correct.
Yeah, have there been any changes in terms of the right to work check?
There's been a certain relaxation there. The government has said that you can send scanned copies of documents via email or mobile app to the employer. And once the pandemic is over, they would expect the employers to check proper documents down the line. Checks via video calls are also possible now. And one thing the employers must ensure is that they must take permission from the employee if they check their documentation on the Home Office Employer Checking Service, which is available on the Home Office website. Because in certain cases, you aren't able to check everything via the employee. So you can go on the Home Office Employer Checking Service and check documents there as well. But like I said, it's important that you seek permission from the employee because the data is all confidential over there.
Okay, great. Let's move into something that's obviously going to be front and center for a lot of individuals, which is unpaid leave. So the unpaid leave really going to impact the temporary or non-immigrant statuses in individuals. Certain non-immigrant statuses in the US require, like we said, that labor condition application that's mandated by the Department of Labor. Marc, in the US, how are unpaid leaves handled?
Like you said, it depends on what work visa status the person's hold. For individuals who are in H-1B, which is the specialty occupation status, as well as E3 status, which is for Australian professionals, both of those categories have a requirement that the employer file and obtain something called a labor condition application, or an LCA, before they can file those H-1B or E3 applications. This LCA document, what it does is it confirms that the employer is agreeing to pay the individual the prevailing wage for the occupation as defined by the Department of Labor, pay them the same benefits that all U.S. workers get, and there are some other attestations that they have to make as well. But in terms of when you're looking at unpaid leave, the key element to look at is the attestation that the employer has said that they will continue to pay the H-1B or the E-3 employee the prevailing wage for as long as they remain actively employed with the employer. So under the H-1B and E-3 category, the employer does not have the ability to force an employee into an unpaid leave or a furlough situation, because that would be considered unlawful benching of the employee, putting them into an unproductive status without pay. That's not allowed. An employer can certainly put an H-1B or an E-3 employee into an unproductive status, but they have to continue to pay them, which really defeats the purpose of a furlough in most situations. So for an H-1B or an E-3 employee, the employer's only choice is to either continue to have that person on the payroll, whether they're actively working or not, and pay them their full wages. The employer does have the ability to potentially issue a salary reduction, maybe a 10 or 20% salary reduction. That's permitted, but in many cases that might require the employer to file an amendment with the USCIS to let them know of that change, depending on the size of the salary reduction. Also, you may choose to reduce hours for an employee, move them from full-time to part-time. Also permitted, but in many cases may require the filing of an H-1B amendment. But the one thing an employer cannot do is, which they can do for a normal U.S. worker, they cannot furlough an H-1B or an E-3 employee without pay, because they are then in violation of the LCA wage payment rules and could have back pay liability down the road. So in those situations, if an employer feels that they cannot continue to employ and pay an H-1B or an E-3 worker, their only choice is to terminate that employee's employment. Now, in the United States, there's within the past couple of years, they've created a new grace period for H-1B employees and E-3 employees, and so if those individuals are able to find new employment within that 60 days, they could have their new employer file a new H-1B or E-3 for them, and they could rejoin and get back to work. Also, if the employer who had to lay them off wants to rehire them within the 60-day period, they can do that as well, but they would have to file a new petition with the USCIS. You just don't have as much flexibility with workers in those two categories. Outside of the H-1B and the E-3, categories like L1, the E visas, O1, and TN, you don't have those strict wage payment issues, but the way those statuses are defined is that an individual is only considered to be maintaining status while they're actively employed with the employer. And so it's a little bit of a gray area, and it's hard to know how USCIS would treat a very short-term furlough where there's a very clear intention of bringing an employee back, but the USCIS would be able to treat that as a end in the employment, and by ending the employment, the person is no longer continue to be maintaining their status. But again, they would also be eligible for the 60-day grace period. So for employers who are going to be, potentially furloughing an employee in one of those categories, if it is short term and you bring them in back within 60 days, that may be something that you may be able to do without any major immigration implications.
Yeah, and I think what's really important, the takeaway from that is, before making any changes to terms of employment, it's really important to make sure you understand the ramifications, because often they may not be able to be recorrected at the back end. Rahul, in terms of the UK, the tier 2s, how has that been impacted with unpaid leave, and how's the UK government handling that?
Well, the UK immigration rules allow for sponsored workers to take up to 4 weeks unpaid leave during any calendar year. But at this moment in time, any absences of more than 4 weeks, sponsors aren't required to withdraw the sponsorship, and it's an exceptional circumstance. The government understands it. So they are taking everything on a case-to-case basis, but there's a relaxation there as far as unpaid leave is concerned.
Okay. I have a question about the sponsors themselves. So if a company who's a sponsor either has layoffs or they withdraw sponsorship, does that impact their ability to hire foreign workers in the future, or they have to get recertified as a sponsor every, I don't know, 2 years or 3 years, 4 years?
So the sponsor license lasts for 4 years, and even if they lay off people, that does not impede them from hiring anybody else once they have laid off a person. So as long as the sponsor license is valid, they can continue hiring people, and as many as they want to.
Okay, that's great to know. In terms of other changes for compliance that individuals should be aware of, again, in the H1B and L context, which is really the non-immigrant statuses that are most common, as Marc mentioned, for the H1B E3s, if there's a material change and it doesn't fall within any of the short-term work exceptions that are allowable if there's a change for 30 to 60 days, typically you'd want to file a new LCA and file an amended petition before that change occurs. The USCIS did announce there is some flexibility, and we discussed it before with having to post the LCA. They allow for a 30-day exception. Again, where possible, the best practice really is to make sure that you comply with the original regulations, which would be to post the LCA as and when the change occurs. If there are changes of your worksite within the same metropolitan statistical area, again, you can post the LCA at the new worksite. You don't necessarily need to file an amended petition with USCIS. There's less government filing fees. And then if we look at the L1 and other non-immigrant statuses that do not require the LCA posting or the LCA compliance, really you need to look at, they don't typically require filing an amended petition, but it really should be a question of fact as to whether there's been a substantial material change that you think USCIS would want to know about, and if it does change the nature of the application itself. Again, reduced pay in those H1B and the E3 where LCA is required. The LCA is really there to protect the prevailing wage and make sure to protect the US workforce as well. So if there has been a reduction in the salary below the prevailing wage listed in the LCA, then you really should file a new LCA and an amended petition. If it doesn't drop below that prevailing wage in the LCA, then you wouldn't need to file a new LCA or an amended petition. And then again, the L1s and other non-immigrant statuses, there's really not a prevailing wage requirement. So again, unless there's a substantial or permanent change, you wouldn't be required to file an amended petition. How is the UK Rahul handling amendments in or changes to conditions of employment?
So in the UK, every employer has access to something called a sponsor management system, which is an online portal. And the employers must report any changes through the sponsor management system, as we call it, SMS here. So because of COVID-19, if somebody is restricted from traveling or is self-isolating, employers aren't supposed to report those absences on the SMS. And as I said earlier, there's no need to withdraw sponsorship if someone's absent for more than 4 weeks on unpaid leave. And if the employee is working from home, again, there's no requirement for sponsors to update the sponsor management system. And as you were saying earlier about reducing salary, that's possible in the UK as well. But it must be reported via the SMS as and when it happens. And we expect it to bring the salary back up after the pandemic is over, because you can't just have somebody on a lower salary than what is stated on the COS. It's very temporary.
Right. The last part of our compliance I think is really important. As airline travel has continued to be disrupted, there are a lot of visitors, both in the US and the UK, who may find themselves stranded for a period of time, or due to medical reasons may not be able to depart when they actually want to. So from the US perspective, if you've entered in on a B1 or B2 visa, I think it's really important that you check your expiration date, not on the visa, but the I-94 itself, which can be found on the CBP website, because that controls your status in the US. So if you are coming up to an expiration date, you do want to make sure you file prior to your B1 or B2 expiration date coming due. And typically they are discretionary requirements, but given the current pandemic, I think it's very plausible that you would be able to get those extensions approved. if you came in as a visa waiver under the visa waiver program, Marc had mentioned that you can apply for a discretionary extension, which is called satisfactory departure. Now, you can either do it at the airports, or there is a USCIS phone number that you can call. I've seen reports just in our immigration community in the US that these are actually getting approved much more easily than they ever have done in the past. Typically, you would get a 30-day extension of your status in the US if you can demonstrate that you're unable to depart the US, and that can also be renewed. So I've seen a couple of reports of practitioners who've had their second satisfactory departure approved for the same individual, which is really rewarding and obviously gives some great hope to anyone here. But it's not intended for you to just continue to remain in the US. It's really a stopgap to keep you safe until you're able to depart the US and carry on. Rahul, in the UK, how are visitors handling being stuck in the UK itself if they can't leave?
Well, visitors who are here in the UK, their leave are automatically extended till 31st of May 2020. But again, that can be further extended depending on when the restrictions are lifted. But at the moment, they are safe. So anybody who comes in can stay up to 6 months in the UK, even if they have a 5-year or a 10-year visa. That doesn't mean that they can live in the UK for 5 years at a stretch or 10 years at a stretch. What that simply means is that they're allowed to stay 6 months in any 1 year. So they need not worry about leaving the UK until 31st May 2020. And what the government has also offered is any visitor who's in the UK is allowed to switch into a long-term visa until 31st May 2020, just giving them flexibility, not to having to go back to their home country and applying for a visa, but they could simply switch their status here. I have seen a lot of people do that in the UK, and it's quite advantageous at the moment because it just saves the hassle of somebody having to go back, because a lot of people who were looking to apply for a sole rep visa or a tier 2 visa or a spouse visa, and this gives them a lot more flexibility to apply in country.